It's Wednesday, it's March 26th, and today I am on the road. As you can tell, I tried to move my suitcase out of the way. Clearly, it's not, everything is fine. Streaming is dynamic, but I am on the road today and was flying yesterday and had no Wi-Fi. So today we are going to cover the Karen Read hearing that happened yesterday. We are going to go through everything that happened in the hearing yesterday, and the judge issued orders yesterday afternoon after court, and we're going to go through those too. Many of you have already seen that the motion to dismiss was denied. Most of you are not surprised by that denial. I think all of us are frustrated that there wasn't an evidentiary hearing. When we cover that ruling, I will talk about it. But the court did issue the order on that motion to dismiss. We'll go through it quickly. We'll do a deep dive probably on the Emily Show podcast that drops every Monday, because today I don't think we're going to have time to deep dive it.
With that law jurisprudential predicate in mind, I now turn to the statements at issue here and their import to that analysis.
You know what, Mr. Leslie, I'm going to stop you. I understand the Commonwealth's argument regarding waiver. I understand that the request is narrowly tailored. I'm not going to give you this information, Mr. Brennan. I don't even think it's appropriate from my eyes, so your motion is denied.
Thank you, Your Honor.
At the end of court today, the thing that surprised me the most in this Karen Read hearing is that when the judge cut off the defense as they were arguing about Karen Read's text messages or other communications with her attorney, David Yannetti, that were on her cell phone, that the court cut the defense off in the middle of their argument and then said, I'm denying this motion. I'm not giving that to you, Mr. Brennan. I was so surprised that that was the court's decision to not only rule from the bench, but cut the defense off in the middle of their argument to rule from the bench and to deny the motion where the Commonwealth was seeking access to those records. I think one of the most persuasive things for me in that, because the court said, I understand what you said about waiver, but I don't know if that means the Commonwealth gets those documents. But the Commonwealth asking the court to dig through redacted information, attorney-client information, and ask the court to decide what gets turned over is a mess. It's a mess of what they're asking the court to do. And so, while I'm surprised the court ruled from the bench and didn't let the defense finish their argument to rule from the bench, I'm not surprised at the end of the day by the court's ruling here and saying, I'm not turning those over. And that doesn't forestall the Commonwealth from seeking to bring in the content of that conversation through Karen Read's interviews, not from text messages, but Karen Read said, this was the conversation I had. That might be able to come in down the road through Karen Read's own statements, but they are not getting the information from Karen Read's phone. I'm still surprised that the Commonwealth asked the court to dig through that and didn't say, either we need the taint team to do it, we need another judge to do it. This judge wasn't going to do that and very much made that ruling clear. We also know that the court granted a buffer zone similar to the way that the buffer zone was granted last trial, that nobody can use audio enhancing devices, so like bullhorns and things like that. Nobody can wear clothing. It doesn't say anything about signs specifically, but nobody can wear clothing talking about one side or the other, and that the buffer zone needs to be 200 feet, and then they extended some of the roads around the courthouse for that buffer zone. And the court made clear that law enforcement, when they come in to testify, cannot be wearing their uniform or badges or anything like that. But they did the 200 feet, but then they also did some other roads that are encompassed. So with all of that, there will be a buffer zone. Again, there will be a crackdown on audio amplification, bullhorns, things like that. No clothing, those types of things. That's what happened in the ruling with regard to the buffer zone. They worked on the scheduling of the trial. The trial is going to start April 1st with jury selection. The court has said repeatedly, I think jury selection is going to take a significant amount of time, and I think the court is right about that. Trial testimony probably won't start until the end of April. So we are going to have about, it looks like maybe 25 to 28 days where the court will be in jury selection. Jury selection is not televised or streamed, but there may be hearings and evidentiary hearings that go on in that time. If they do, I will stream them. You're going to have the Law & Order app as we get into trial season, because sometimes those are unexpected, and so we can't always plan for them. And I can let you know in the Law & Order app if we're going to go live unexpectedly or shift around the time of a live to accommodate trial. Oftentimes that has been bumping things a little bit earlier than my normal streaming time to accommodate the court on East Coast time, even though I am in Central Time and a lot of you are in different time zones around the world. Law & Order app is free. LawandOrderApp.com will get you there, and that's how you can stay in the loop and not miss anything that's going on during this trial. I think evidence will start either the 25th or the 28th, and that will be interesting to see how long it takes. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law & Order app at LawandOrderApp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.